The H1B Guy here. And today, the H1B Guy news for the week ending January 26th, 2024. Today, I'll cover LCA updates issued for H1B remote workers and F1 and OPT travel guidance during the H1B lottery. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube and like this video so that I can continue to produce more content like this for you. I also wanted to mention that H1B Guy offers a variety of consulting services. I help businesses and individuals solve complex work authorization issues in the recruitment process while bringing awareness to employment-based immigration benefits. If I can help you, please reach out. I'd love to hear how. And you can book an appointment directly with me via the h1bguy.com. Today's news is brought to you by Syndesis, the annual Plan B for high-skilled immigrants currently located in the U.S. whose status may be uncertain, by PERM-Ads.com, the industry leader in providing a seamless experience for employers and immigration attorneys, navigating the complex PERM recruitment ad phase of the labor certification process, and by Mob Squad. Are you a technology professional facing U.S. work visa-related challenges? Don't leave your fate up to chance. Our partner, Mob Squad, has a solution. Join the squad. Now, the news. First off, I wanted to say thank you. Earlier this week, the H1B Guy channel here on YouTube crossed over 6,000 subscribers. I'm very grateful to each and every one of you and for your continued support. On Wednesday, January 31st, I'll be hosting my good friend Sophie Alcorn from Alcorn Law, as well as Ask Sophie, a column on TechCrunch for the H1B Guy Live, and we'll be covering all things H1B lottery and more. Please make plans to join us next Wednesday, January 31st at 2 p.m. Eastern. I'd also like to kindly ask you for your vote. I've recently been nominated as a staffing leader to watch in 2024 by the World Staffing Summit. Voting does end on January 31st, so I will post a link in the video description below, and your support is greatly appreciated. And one last personal note, a huge shout out to the entire team at Tier 4 Group. In celebrating our 10-year anniversary, we had an amazing week during our kickoff with my good friend Casey Jaycox as our keynote speaker, and ended it with an amazing party to acknowledge the very special occasion with our clients, candidates, friends, and family. On January 23rd, 2024, Sarah Belletti for Holland and Hart, in a post titled Looking Ahead to the 2024 H1B Cap Lottery and Other Developments Employers Should Watch For. Quote, H1B employers should closely monitor work locations for remote workers. Beyond the H1B cap lottery, a recent appeals court decision underscores the need for employers to closely monitor work locations for remote H1B workers. H1B workers are permitted to work only at the locations listed in the H1B sponsorship petition filed by their employer. This is largely due to the associated labor condition application and prevailing wage requirements designed to prevent wage discrimination for foreign workers. The prevailing wage rate is defined as the average wage paid to similarly employed workers in the requested occupation in the area of intended employment. USCIS regulations state that employers are required to file an H-1B amendment on the employee's behalf if any material change occurs to the employee's current authorized employment. This includes significant changes in job duties, salary, and worksite. The H-1B amendment must be filed before the material change in employment occurs. Typically, if an H-1B employee is working remotely, their home address is listed as one of the work sites on the original LCA accompanying the H-1B petition. If the employee moves outside of the county or geographic area listed on the LCA, this is considered a material change and an H-1B amendment must be filed. Considering this, it is important for employers to implement a system to monitor remote work locations and advise employees to notify them of potential change in remote work location. An H-1B amendment can introduce unwanted scrutiny into a foreign national employee's maintenance of status. This is an issue that's been ongoing for more than a decade plus, as many high-tech roles that H-1B visa holders occupy have been fully remote or hybrid. The running joke for years has been, yes, you really have to post your LCA on your refrigerator or home office. There's been multiple attempts at clarification to this aspect of H-1B remote work over the years that dispel the necessity of the refrigerator LCA. I've always warned that it's better to be safe than sorry, and I'd much rather you have the LCA certified with the home address and work address both. The emphasis on material change is really important to note here, especially when you're considering moving residences and how that can impact your status. By simply changing remote work locations, prevailing wage determinations for the metropolitan statistical areas could fluctuate significantly. This is still sound advice, and even if it's an additional expense, it does remove the risk of failing a potential future site visit, which is absolutely something that you want to avoid. On January 23rd, 2024, Kimberly Best Robidoux for WR Immigration in a post titled H1B Cap Travel FAQ for F1 Students. Quote, if an individual in F1 status has an H1B cap petition that is pending with USCIS, a change of status, they cannot travel abroad and re-enter the US without abandoning the change of status request. Once the H1B petition has been approved as a change of status, the individual in F1 status may travel abroad and re-enter the US prior to October 1st, and their status will automatically change the H1B status on October 1st. It is very important to note that individual in F1 status must have the appropriate documentation to re-enter the US pursuant to F1 status. Otherwise, they will likely need to remain abroad, apply for and be issued an H1B visa stamp to enter the US no earlier than 10 days prior to October 1st or the beginning validity of the H1B petition if it is after October 1st. If an H-1B petition is filed for consular notification, an individual in F1 status may travel internationally and re-enter the U.S. pursuant to F1 status if the individual has been maintaining F1 status in the U.S. and provides the appropriate documentation for re-entry into the U.S. In order to activate the H-1B status after approval, the H-1B petition by USCIS, the F1 student will need to leave the U.S., apply for and obtain an H-1B visa stamp from a U.S. consular post abroad, and then return to the U.S. to be admitted pursuant to H-1B status. If an international student travels abroad after H-1B petition has been approved and has a valid OPT or STEM OPT extension, they may apply for a new F1 visa if they will be returning to the U.S. prior to October 1st. Please note that any visa issuance is always discretionary by the consular officer, and visa processing times may take longer than expected, especially if an individual's application is subject to administrative processing. Thus, it is critical that whether or not travel and apply for a new visa stamp after approval of the H-1B petition and prior to the effective date of the H-1B petition to be discussed with the company and counsel. Individuals in the U.S. pursuant to F1 status with an OPT or STEM OPT extension could potentially have their EAD work authorization extended beyond the expiration date if their registration is selected in the H-1B cap lottery. An individual must be an authorized period of post-completion OPT or STEM OPT extension on the date that the H-1B sponsoring employer files the H-1B change of status petition with USCIS. Provided that the H-1B petition is timely filed, an individual may be granted a cap gap work authorization valid until at least September 30th. It is recommended that an F1 student in this situation not travel abroad during the cap gap. Any decision about travel in this situation could and should be discussed with the company representative and counsel. If an individual in F1 status on the cap gap extension and has an approved H1B change of petition status, they must have at least one passport valid for at least 6 months beyond the intended period of stay in the U.S., valid F1 visa stamp, valid Form I-120 endorsed by their ISO DSO for travel. It is also recommended to have the expired EAD card as well as a letter from the employer confirming employment in the U.S. So I covered a majority of the answer portion of the Q&A from this post because it actually answers a lot of questions around travel for individuals on F1 and OPT that I'm frequently receiving, and admittedly, I don't always know the correct answer. I think this post does a really good job of summarizing the do's and don'ts for traveling when an H-1B application is pending, when it's approved, and when the cap gap rule comes into play. As a reminder, my biggest takeaway was really from the very beginning, and that is the emphasis on you'll need to have the appropriate documentation, regardless of status, if you want to re enter back into the US. If an H-1B stamp is required via consular processing, that can definitely add additional time, as obtaining appointments can still prove to be very challenging. My best recommendation is not traveling until you have your H-1B approval and have changed status on and after October 1st. However, if you must travel, I cannot reiterate this enough. Make sure you have all of the appropriate documentation, evidence, and points of contact for your employer in case you need them. There's still no official word on when the H-1B lottery for fiscal year 2025 will open for registrations, but I expect we'll hear something really soon. For the full post on the H1B Guy news for the week ending January 26th, 2024, please check out the h1bguy.com. And a reminder that today's post is brought to you by Synthesis, the ideal plan B for high skilled immigrants currently located in the U.S. If you're facing an H1B denial or OPT expiration, don't get caught off guard. Make sure you have a plan B, and Synthesis is your answer. They'll gladly help you navigate the process, and if you'd like to find out if you qualify, please be sure to use the link in the video description below, and someone from Sedesis will be in touch. By PERM-Ads.com, the industry leader in providing a seamless experience for employers and immigration attorneys navigating the complex PERM recruitment ad phase of the labor certification process. If you're looking to reduce your costs and overhead associated with PERM labor certification recruitment advertising, let PERM-Ads.com help you. And by Mob Squad. Are you a technology professional facing U.S. visa-related challenges? Don't leave your fate up to chance. Our partner Mob Squad has a solution. Mob Squad helps technology professionals facing U.S. work visa-related uncertainty remain working with their current U.S. employer nearshore from Canada, as well as technology professionals from around the world who are seeking to find a rewarding opportunity in North America. Through their partnership with the Canadian government, they can obtain a Canadian work permit for you and your spouse in as little as 4 to 6 weeks. So, whether you're looking to stay working with your current U.S. employer or you want to find a new opportunity in Canada, please find out how the team at Mob Squad can help you via the link in the video description below. Join the squad. Just wanted to ask you again to please like this video, subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications so that you're notified anytime we post new content here to this channel. If you've made it this far, I just want to say thank you for taking the time to watch my video. Really appreciate your support. The H1B Guy, your global source for all things H1B.